I will just let people know that I am coming to you from CFAM's office in Northern Virginia. We are in Great Falls, where we moved last year. We were in downtown Washington, D.C. for many, many years, near the cathedral. And then we moved out to Tyson's Corner for a couple of years, and then finally landed out here. It's like being in the country. It's quite bucolic here on the Village Green in Great Falls. Stefano is coming to you from high above the city streets in New York City. What street is the CFAM office on? 3rd Avenue?
3rd Avenue and 47th.
Yeah, yeah. A hop, skip, and a jump from UN headquarters. CFAM has had an office within a quick walk of UN headquarters now for 24 years, which gives us a unique vantage point in following the UN debate on a day-to-day basis, and meeting with diplomats, which we have done continuously all these many years. It is quite astounding that CFAM supporters and donors have kept us going all these years so that we could have an office, and such excellent personnel as Stefano and others there in New York City, so close to the action. So that's where Stefano is coming from. You can have a glimpse of out his window of some of the tall buildings, and there you go. That's a nice view.
It is quite a nice view. I mean, compared to your old office when you were here in New York, Austin, you had the windowless office at 866 UN Plaza.
The closest office that we ever had to the United Nations was at 866 UN Plaza, and both of the offices that we had in that building had no windows. So we had no idea what the weather was even like. And one was a teeny tiny office, the other one was a little bit larger. Just a note to donors, we've always spent your money frugally and well. Here is CFAM Great Falls. Isn't that lovely? So what are we looking at? We're looking at 1103. Stefano, should we begin?
I think so.
My name is Austin Roos. I'm president of CFAM, the Center for Family and Human Rights. We have been following, examining, fighting UN documents since CFAM was founded in the summer of 1997. Prior to that, CFAM founders went to the Cairo conference in 1994 and also the Beijing conference in 1995. And then it became quite obvious, mostly at the urging of the Holy See, that there be an office, a full-time office of laymen working on these issues every single day. And there goes the fire truck on Georgetown Pike, one of the oldest highways in America, I will say. And so we've been working on these issues now for such a long time. And one of the great blessings of CFAM is the stability also of our staff. Lisa Carenti, whom many of you know, has been with us more than a decade. Stefano has been with us more than a decade. Rebecca Oas, more than a decade. It is quite astounding when you get an enthusiasm for defending the unborn child at the international level, and to have the privilege of working on this issue at the United Nations. It's quite a remarkable thing. So today, we're going to be talking about something that is right in CFAM's sweet spot and has been since our founders went to the Cairo conference in 94 and Beijing in 95 and the International Criminal Court a few years later, and so much else. And that is the obligations that governments have under international law with regard to the unborn child, with regard to abortion. As you all know who follow these issues with us, this is pretty much what we do. And this is the value added that we bring to many debates. And now the debate has come to the United States Supreme Court that is now considering a case called Dobbs, which comes out of the state of Mississippi. And it's a case that we'll talk more about it, but basically it's a case about restricting abortion after the unborn child can feel pain. And so there are questions of international law which have already been raised. They've been raised now for many, many years, and we have answered them. But they have been raised in this particular case. We have submitted a friend of the court brief to the court, answering some of these claims of international law, and also examining what are the treaty obligations that the United States has now under international law. But I want to start way back and do a quick tour of case law here in the United States, because quite frankly, even people who follow this closely may not know some of the ins and outs of what has happened in some of these cases. So I want to begin with Roe v. Wade. Roe v. Wade was a case in the U.S. Supreme Court which imposed abortion on demand on all 50 states. And it used a system of trimesters, and said, and Stefano, if I get anything wrong, jump in and correct me, because you're the legal beagle. Set up a trimester regime such that after the second trimester, abortion is supposedly banned unless there are issues related to the woman's health. Now, the issue with Roe v. Wade is that it did not define health. So what is health? In the exact same day, and this is what a lot of people don't know, is in the exact same day, the Supreme Court issued a decision in something called Doe v. Bolton. And in Doe v. Bolton, the Supreme Court defined health. And the definition of health in Doe v. Bolton is so broad, so wide, that it's what gave us abortion on demand through all 9 months of pregnancy. Now, one of the problems that pro-life advocates have encountered over the years in debating these issues in the public square is that the abortion side just loves to point out, well, golly, nobody can get an abortion after the second trimester because of Roe v. Wade. That is false, because they leave out Doe v. Bolton, which defined it so broadly. These types of restrictions on abortion still exist in legislative law in many states, and abortion advocates will point to that and say, see, you can't get an abortion. But the overriding law of the United States are these two cases, Roe v. Wade and Doe v. Bolton. And so how am I doing so far, Stefano?
Yeah, no, just to emphasize that the framework that Roe v. Wade created for abortion was wholly judicially imposed. You know, there were policy debates going on about abortion throughout the United States at a state level, in state legislatures, by politicians elected by the American people. And what the Supreme Court did is essentially it took away that debate away from the people, and put it in the hands of the 9 justices of the Supreme Court. Another little known fact is how influential Roe v. Wade was, not just here in the United States, and its effect was international in scope, because in many ways you could talk about Roe v. Wade as being a primordial act of judicial supremacy. It epitomizes the kind of rule by judges that we are seeing take over in many parts of the world, and the undermining self-government. We've seen it in this particular case. And we've seen it also cited as an example to be followed all around the world by abortion advocates. And so a lot of people here in the United States, but generally people around the world, don't know how influential the Supreme Court is. But I can tell you right now that the Supreme Court cases are cited by just about every Supreme Court in the world. Right. Just last month, the Supreme Court of Mexico cited Roe v. Wade in its decision overturning the abortion laws of the state of Veracruz in Mexico. And, a couple of years back, the Supreme Court of India cited Roe v. Wade and Planned Parenthood v. Casey, the sweet mystery of life passage, Kennedy's famous sweet mystery of life passage, in overturning India's buggery laws. So,
I don't want to get too far over our skis in our conversation, but do you think that if the Supreme Court overturns Roe v. Wade in the Dobbs case, whether it will be equally as influential around the world? I'm skeptical that it would be, because I think that the abortion extremism has become well embedded in the souls of individuals in positions of power around the world and in their legal systems. So I think that overturning Roe through Dobbs won't be quite as influential as Roe was over the years. What do you say?
I think that's very possible. At the same time, it could be a moment in time that reverses the momentum or takes away at least the steam from the abortion movement internationally. I mean, right now, we saw Ireland fall, we saw Chile fall, now just recently San Marino, Argentina, the Supreme Court of Mexico. Just 10 years ago, the Supreme Court of Mexico said the views of UN experts were not binding on Mexico, and therefore there was no international right to abortion. 10 years later, the Supreme Court of Mexico said the opposite, that there is an international right to abortion based on the recommendations of UN experts. So the abortion,
the non-binding recommendations,
the non-binding recommendations. So here we have a lot of momentum for the pro-abortion side, and it is precisely through the kind of decision like Roe v. Wade, judicial decisions or executive actions that undermine democracy and self-government. And so I think an example of a judicial responsibility from the Supreme Court, where they restore power to the people, where they give back the authority to the legislature, and where they also judiciously interpret international law. I think it would be an incredible positive example. And while it may not be followed overwhelmingly or in the majority of cases by foreign courts, because, as you say, the ruling elites globally have been so pervaded by this corrosive abortion ideology, still there will be cases where it will be influential. There are many countries where the legal profession and the judiciary are still maintain a conservative presence, a socially conservative presence, and that's where it would be most influential.
Let's move on a little bit in history, because things changed. Now, I want everybody to know we're going to get up to the Dobbs case, and we're going to get up to the amicus brief that CFAM submitted to the court, also an amicus brief that UN experts have submitted to the court, making their arguments that there is an obligation in international law to uphold Roe v. Wade. But I still want to keep going on history a little bit more. After the next big case after Roe and Doe was the Casey decision, which changed the argument in the legal regime, and essentially said that, well, two things: that the court could not overturn Roe v. Wade because they would lose credibility, which is such a lame thing to say, and that they would that women had come to organize their lives around the ability to get an abortion. What other major things did Casey do to the law? It seems to me that Casey is the law that the court has to deal with now more than Roe, but I could be wrong about that. What say you?
So Planned Parenthood v. Casey essentially left the central holding of Roe v. Wade intact, but modified it significantly at the same time. It should be noted, though, that most of the judges in the Casey decision recognized that Roe v. Wade was a bad decision, mm-hmm. that legally it was unsound.
Yeah, they said that in Casey?
Yes, they said it, but they basically said that it would be too difficult because of the reliance that women have placed on that decision to to have abortions and to build a life based on abortion,
Right.
that they couldn't change the decision. But what Casey did was it basically made it supposedly it was supposed to make it easier for states to regulate and restrict abortions. Under the Roe v. Wade ruling, there could be no restrictions on abortion in the first trimester.
Mm-hmm.
In the second trimester, there could be restrictions on abortion if there was a compelling interest of the state to protect maternal health.
Mm-hmm.
And in the third trimester, the state had broad ability to regulate abortion so long as it allowed for abortion in cases, in the hard cases, when it threatened the health of the mother. And so but what Casey did is it replaced that framework by only drawing a bright line at viability. So essentially, the court said post viability, it remains the same. In the third trimester, the situation is the same. States can forbid abortion, but they must allow it in cases where the health of the mother is in jeopardy. But in the first two trimesters, now the court said that the restrictions in the second trimester, the court said that restrictions on abortion are weighed according to a different standard. So under Roe v. Wade, the restrictions were analyzed under a strict scrutiny standard, which is used for fundamental constitutional rights, which is basically the highest degree of protection that the law affords any right, which means, and it's a very difficult test to pass. A law, in order to pass this test, an abortion restriction, it was almost impossible because the state has to demonstrate that it has a compelling interest and that it used the least restrictive means to regulate abortion. So you can imagine very few abortion restrictions passed muster under that standard. So what the justices, and it's thought that this is especially Kennedy and O'Connor in the Casey decision, what they thought was, well, we'll modify the standard so at least some abortion restrictions will survive scrutiny. And so now the abortion restrictions supposedly will pass muster so long as they do not impose an undue burden on women accessing abortion.
So it's a lower standard.
Supposedly, but what we saw in 2016 with the Supreme Court case Hellerstedt is that in effect, even Justice Kennedy was not willing to allow any kind of regulation of abortion. This was a case coming out of Texas where Texas had a law similar to many other states that were adopting this kind of laws, imposing requirements on abortion clinics that they be similar to other ambulatory surgical centers, so wider doors so that a stretcher can come in.
Let's pause right there for a second, because one of the things that Casey did was to, in this new standard, was it unleashed the creativity of the pro-life movement, did it not?
Well, I mean, the creativity, the pro-life movement had already been trying to have abortion restrictions passed under the strict scrutiny standard, but there was no way to pass. And so, yes, what happened with Casey is, the pro-lifers, we thought, yes, hey, here we have a door open. Now we can try and create all sorts of restrictions to abortion, and even to restrict abortion out of certain states, as is happening in some cases, or at least to drastically reduce the number of clinics providing abortions.
But before you go to the fact that the court hasn't upheld these very creative ideas, let's stick for a second on these creative ideas, because folks ought to know that in the States, pro-lifers passed several hundred abortion restriction laws, and they were very clever. As you said, I want to linger over that for a second. Making abortion doctors have visiting privileges? What's
admitting privileges? Yes,
admitting privileges at the local hospital. Now, in the case of abortionists, abortion providers, they're largely an unsavory lot, and not all of them could get these types of privileges at the local hospital. So this was intended to hobble the abortion industry. Also, in some of these cases, requiring a local abortuary to have the same type of safety and architectural standards as a surgical center. So as Stefano said, wider hallways for gurneys and all sorts of things that made it very, very difficult for some of these abortion clinics to remain in business. And indeed, many of them closed. You know, I think in the state of Mississippi, did they not celebrate some years ago the closing of the final abortion clinic, or maybe one more clinic? I think in Missouri, they celebrated in the last 12 months the closing of the final abortion clinic. So these very creative ideas have had an effect. And additionally, it allowed pro-lifers, see, there's this great big boulder in front of the pro-life movement, Roe, Doe, Casey, that prevent the pro-life movement from making abortion illegal. So it has forced the pro-life movement to get very creative in all these ideas. The partial birth abortion debate, for instance, grew out of this whole idea. Very creative. And where it didn't ban abortion, it banned an abortion procedure. So the pro-life movement is remarkable, has never given up and come up with very clever ideas. Now, the newest wave of these are these pain bills, heartbeat bills that seem to have finally reached the level of the Supreme Court and is where we are now. The Supreme Court did not uphold the Texas bill. Was that a heartbeat bill or a pain bill?
So the Texas bill is a heartbeat bill, and the Supreme Court basically refused the challenge,
right,
to the bill, which is
now some say that there is a tactical reason and that we cannot necessarily read the tea leaves, that the Supreme Court has gone sideways on our issue. What is that explanation?
I'm not sure which one you're referring to. I know that the Texas bill, there will be other challenges. They're just waiting. They're waiting for a live challenge to the bill to come to them. They don't want to rule on the bill until people have been actually affected by it. And that's normal for the Supreme Court. They're going to wait for a live controversy to take place as opposed to a theoretical one. With regards to the Mississippi case, though, the Dobbs case, well, I know my constitutional law professor, Jerry Bradley at Notre Dame, he wrote an article in the National Catholic Register, which was quite persuasive in my view, arguing that the Supreme Court must be willing to review Roe v. Wade and all its abortion jurisprudence, because it wouldn't have taken the Dobbs case so soon after Hellerstedt in 2016, right? When essentially it's the same issue at stake. We're still talking about pre-viability restrictions on abortion. So,
now, the unique aspect of I think it's the Dobbs case is that it allows individuals to sue. That's
the Texas? That's the
okay. Let's stick on the Texas law for a second. One of the issues of previous pro-life legislation is that they are so quickly knocked down by the courts because the court is stopping a government from doing something. And in the Texas case, and I know this has been criticized by big pro-life players, including our friends in the pro-life office of the USCC, the U.S. Conference of Catholic Bishops, that it wasn't a prudent approach because it allowed practically anybody to civilly sue a doctor for committing an abortion. Now, maybe had they kept it to somebody who forced a woman there, or the doctor himself, but it's been spun by the other side that it could be anybody, including the taxi driver who delivered her there. But the genius of that, it seems to me, is that the courts cannot stop one of 10 million people from suing civilly against a doctor who commits an abortion. Am I right?
So it's testing the limits of U.S. abortion jurisprudence. It's just another example of pro-lifers being creative.
Yeah.
So here we've had a lot of regulation, administrative regulation, criminal laws that have been repeatedly struck down by the Supreme Court based on Roe v. Wade and the Planned Parenthood v. Casey. So now Texas said, okay, let's try civil penalties. Let's try a private right of action,
Right.
and see what the
Which
Supreme Court
has
wants to
been
do.
allowed in other areas of the law, private rights of action.
Yes, the question now is whether the Supreme Court, of course, those on the pro-abortion side are very quick to say, well, this of course is going to get struck down. There's no way this is going to survive. But I think where these laws really are important, more than especially the one in Texas. I think what's really important about them is that they keep showing that Roe v. Wade is unsettled, that it's not accepted.
Yeah.
Because one of the things that the Supreme Court always says is that once something is settled precedent, once a ruling has been accepted and it's settled, then it's very hard to change it. But what these laws demonstrate is that Roe v. Wade, in fact, is not settled precedent, that there's constant movement at the state level in the courts, having to revisit the contours of Roe v. Wade and even the central holding of Roe v. Wade, the whole pre-viability and post-viability framework for judging abortion restrictions. And so, and that's what raises really hopes that the Dobbs case could be the one where the Supreme Court returns the issue of abortion to the states. And in fact, I know there's others who ask the court to go further. Who argue. There's a brief by Robbie George in the case, arguing that the post Civil War amendments to the Constitution protect unborn life, and we are actually also are asking the court to go further than just a reverse Roe v. Wade. We are asking the court to make a positive finding that international law does not establish an international right to abortion.
Right.
And that
well, before we move on to there, and I want to move on to there in just a minute, all of these cases you say shows how unsettled abortion is in the United States, but it also shows, it demonstrates to the world how abortion is not settled in the world, which is a very important aspect of international law, because customary international law requires a kind of settlement, a global agreement on these things. And I always point out to people that the pro-life movement is the hope of the pro-life world, because it shows that even here in the heart of a country that has the most radical abortion regime in the world, it is unsettled. And that means it's also unsettled in the whole world. Even as Mexico imposes abortion on its citizens, even as San Marino does too, the fact that there is such struggle and strife and disagreement in this country shows that there's struggle and strife on this issue all over the world.
Absolutely, it's so important to contest. There's here in the United States, we have a sort of a little bit of risk aversion to battles that are difficult to win. The abortion battle, especially in the grand scheme of things, it's a very difficult one to have. It's a war that we seem to be losing in the long run, but at the same time, it's so important to fight that battle precisely, at least when it comes to the international side of it, precisely to show that the issue is not settled, that the issue is not settled.
I would disagree with you there for a second, that you say that it seems like we're losing. I say it seems like we're winning. And maybe that's just the difference in our personalities, because 30 years ago, only 25% of Americans, according to Pew, maybe it's Gallup, self-identified as pro-life. And now that's evenly split. Sometimes it's 49, sometimes it's 51. And this shows a huge change, in American understanding. I mean, the American understanding of the abortion regime is also quite confused. Most people will say that they are pro-Roe because they don't know what Roe and Doe did. But then they will say that abortion should be radically restricted, even to rape, incest, and save the life of the mother. If we had that, it would eliminate, thousands and thousands of abortions in this country. So most Americans are in favor of that. My worry, Stefano, is that we will end up in a place where abortion will be allowed in many of the larger states in this country. Well, for any reason, but in many other countries, in many other states, it will be rape, incest, save the life of the mother. So in my view, my fear is that it will be only in a few states where abortion is outlawed completely.
And
Missouri,
that's the most likely scenario, at least in the short term. So even if the court were to reverse Roe v. Wade, it would set up,
50 state battles.
A state debate about it. At the state level, there would be debates about it. And it's true, most likely there would be few states where there would be a complete ban on abortion.
And this is something that Americans need to understand, is that it's highly unlikely that the Supreme Court will impose a universal protection of the unborn child from abortion in the United States. What they'll do, from our point of view, the best that they will do is to return it to the states, to overturn Roe and return it, Roe and Doe Casey return to the states. So let's move on. We've got about a half an hour left. Let's move on to our sweet spot. And the reason that CFAM was created was to debate, well, first of all, to ensure that abortion didn't become an internationally recognized human right in UN documents. And that tees up perfectly our intervention in the Dobbs case. So talk a little bit about our amicus brief in the Dobbs case. What are the arguments that we make, and why are they important?
So I had an inkling when I saw the Dobbs case come up, and when I started reading about all the buzz about it, the possibility that the Supreme Court might reverse Roe v. Wade, and I thought already a couple of years ago, I was thinking how important it would be for the Supreme Court to weigh in on the issue of whether international law establishes an international right to abortion or not. And I thought, wouldn't it be great if the Supreme Court, when it reversed Roe v. Wade, would also say that abortion is not an international right, essentially rebutting all the claims that we've been documenting for the last 25 odd years from the United Nations human rights system, all these non-binding recommendations from UN experts, UN treaty bodies, etc., stating that abortion is an international right. And I thought, wouldn't it be great if the Supreme Court just set out, which is the most influential court in the entire world, wouldn't it be great if the Supreme Court were simply to just say, actually, no, there is no international right to abortion, and sovereign states never agreed to such a right in any international treaty, and therefore it's perfectly consistent for US states to decide for themselves how to regulate or restrict abortion. And I had the suspicion that UN mandate holders, these UN bodies, the treaty bodies, or the UN experts, would actually submit an amicus court brief, to the Supreme Court in this Supreme Court case. And my suspicion was confirmed this month when it was published on the Supreme Court docket. 7 UN mandate holders. Essentially, it's just 2, really. It's the Special Rapporteur on the Right to Health and the Special Rapporteur against torture, as well as the Working Group on Discrimination Against Women, which are these UN bodies, which probably most of you have never heard of, but within the United Nations, they are well known, and they are UN experts, which can issue recommendations to states about what their human rights obligations are. And these 7 UN human rights experts submitted a friend of the court brief to the Supreme Court in the Dobbs case, arguing precisely that abortion is an international right. And unsurprisingly, of course, they are unable to cite a single binding provision of a UN treaty to support their claims. I mean, they're literally, you can read the entire brief.
Let me ask you a quick question. The sum and substance of their argument is not that they can point to any particular document, because we know that they can't, either binding or non-binding. But what they do is they quote other human rights experts at the UN who say that there's a global right to abortion. Right?
Not just other human rights experts. Most of the time, they're quoting themselves and their own reports. It's quite extraordinary. Yeah. And we laugh about it because, of course, we find it comical that these UN experts would go to the Supreme Court and say, hey, we are citing here very high authority on human rights. And yeah, that's me. So right. These literally the Special Rapporteur on the Right to Health, the Special Rapporteur against Torture, the Working Group on Discrimination Against Women, these are the most aggressive promoters of abortion within the human rights system. And most of the recommendations that are cited are from them. There are also some from the Human Rights Committee, which is the treaty body that monitors the implementation of the UN Treaty on Civil and Political Rights, which the US has ratified. That's the closest they come to even getting close to what US obligations are under international law. But of course, the Human Rights Committee's recommendations also are not binding on the United States. And in fact, the United States has butted heads with the Human Rights Committee on many occasions, rejecting its recommendations.
Well, I would point out, however, that I just lost my train of thought. Sorry about that. There was a note that came up from one of our readers asking if our amicus brief is available online. Do we have this up on our website?
It's on our website. I'll put it in the chat box as well.
Okay.
But it's on our website. It's also on the Supreme Court docket. It's in the Supreme Court website. So,
these guys, these treaty monitoring bodies, for instance, and this is one of the things that they cite in their amicus brief, is, for instance, one of the treaty monitoring bodies says that the right to life is now interpreted as a woman being able to get an abortion. So they make wild claims about what these things mean. And these are treaty monitoring bodies that are supposed to review the implementation of hard law treaties by UN member states. They have taken it upon themselves, and you can talk more about this, in recent years, to reinterpret these treaties. For instance, a treaty monitoring body now, 10 years ago, told the Catholic Church in the guise of the Holy See that certain teachings of the Catholic Church are in violation of human rights in the human rights law. In the recent report by the LGBT czar at the United Nations, Victor Madrigal-Borloz, said that the teachings of the church are in violation on LGBT and gender theory and gender ideology, specifically the family, are in violation of existing human rights law. These are false claims. These are false claims. Nonetheless, these false claims are cited and have been cited by courts around the world, in Mexico, for instance, when they imposed abortion, and in other places. So these are not, they're empty claims, but they're fully loaded claims that judges around the world take quite seriously.
That's right. And one of the things that I found so crippling to the pro-life side, even when we had the Trump administration in power, and it's because of is the conservative sort of aversion to international bodies and international things generally. There's just a general misunderstanding of the nature of the United Nations and its influence. And so if you cite, UN treaty bodies, and, we've always been outraged by this, by UN treaty bodies promoting abortion, UN experts promoting abortion. And, you know, you can go to a conservative organization or any conservative and say, look what they're doing. This is terrible. And they will sort of yawn and go like, oh yeah, it's non-binding and we shouldn't worry about it. Right.
Yeah.
And inevitably, though, these recommendations are influential. Not only are they adopted by UN agencies and promoted around the world through billions of dollars of international development aid, but they are also taken up by foreign courts and governments. And get this, our own government here in the United States is taking up these views more and more. Not only have they intervened at the Supreme Court, you know, 4 years ago, they intervened in the state legislature of New York. And there's nothing to stop them from intervening in other state legislature debates and coming in as the UN experts and saying what the international obligations of the state of New York are.
Well, and just keep in mind, and this is what I was trying to think of a few minutes ago, the Supreme Court itself has used foreign law and UN law with scare quotes, in interpreting our own constitution, for instance. And this is in the context of members of the left wing of the Supreme Court spending their summers in Europe, going to conferences on the, you know, on the importance of foreign law and interpreting the US Constitution. Justice Kennedy would spend every summer in Europe going to these kind of conferences, so that when the Supreme Court overturned the so-called juvenile death penalty, that two Supreme Court two UN documents were cited, both hard law treaties. One was the Convention on the Rights of the Child, which the United States has never ratified. So they cited a document in the juvenile death in overturning the juvenile death penalty, a document, the Convention on the Rights of the Child, which is we've never ratified. But they also cited the International Covenant on Civil and Political Rights, which we have ratified. But the part that they cited in the juvenile death penalty case was a part that we reserved on. That is to say, when you sign a document, when you ratify a document, you can make reservations that say we agree with everything but this part. Well, we didn't agree to this one part on the death penalty, yet that is the part that the Supreme Court cited. Now, we have a new Supreme Court now, and the Kennedy types are fewer. I don't necessarily trust Justice Roberts in this particular area. I don't know where the Supreme Court has been in recent years in citing foreign documents, but I fully expect that Breyer, Kagan, and what's her name, who's the smart Latina, who's the wise Latina? I can't remember. Sotomayor would be more than happy to cite existing UN documents on this. I mean, I have long said in my public statements and speeches and lectures that when Roe v. Wade is eventually heard again, which very well could be Dobbs, UN documents will be cited by the majority if Roe is upheld, and by the minority when Roe is struck down. I think it's an absolute dead certainty that UN documents and statements of treaty monitoring bodies will be cited in the decision of upholding or striking down or in dissent. What say you?
Oh, I agree 100%. In fact, I have no doubt that Sotomayor, possibly Kagan, and Breyer also will raise points about international law in oral arguments on December 1st. Yeah. I just hope that the Council for Mississippi is prepared to answer them, because I know this is just an area that is very sophisticated, very complex, and that very few American lawyers are prepared on. Sorry?
Are we in touch with them to help them?
We will get in touch to sort of suggest our you know, highlight our brief and our possible responses to questions on this issue. I mean, I have no doubt that, you know, it's a possibility that Sotomayor will come up and ask things like, didn't we agree to an international right to abortion in 1994 at the International Conference on Population and Development, which is what the UN experts said, which is, it actually contradicts the text of what was agreed in 1994 at the International Conference on Population Development, where abortion was expressly excluded as an international right. So I think there's a lot going on here. We are really seeing how the influence of these international mechanisms coming to fruition in a lot of countries. We saw it in Colombia, we saw it in Mexico, and we're seeing it also in the U.S. Congress. I mean, just this month, the Women's Health Protection Act, which has been in the news, in the pro-life news, because it's trying to respond to the Texas law. It's trying to create protect the abortion industry from lawsuits or any kind of regulation at the state level. And but the Women's Health Protection Act, which is a bill proposed by Democrats in Congress, it also lists abortion as an international right. It describes abortion as an international right based on the recommendations of UN experts, the same recommendations cited in the Supreme Court brief of the UN mandate holders in the Dobbs case. So we are having members of Congress trying to enshrine abortion as an international right in US legislation. Right. That is a very significant development. We've never seen that happen before.
And as we're reporting this week in the Friday Facts, Joe Biden has become the first president to endorse the idea that there's an international obligation with regard to abortion in this particular law, because he's endorsed it. This is something that Bill and Hillary, maybe they considered it, but they rejected it. I mean, they formally rejected it. Obama formally rejected it. So here is Joe Biden, faithful Catholic, don't you know, endorsing the idea that even if Roe v. Wade is struck down, the presumption is that we have an international obligation to keep abortion legal, which is preposterous. Quick question, and I want to let the folks know that we are open for questions, either in the chat or in the Q&A, and I've got them both here. Somebody asked about whether the document is shareable. It is now up in chat. It is up on our website. Now I know that we're not necessarily ready with the final report on this. I know that our colleague Alexis is doing an analysis of all of the friend of the court briefs, and I think that there are dozens of them, and looking at how many of them cite international law. Do we have any idea, at least preliminarily right now, how many have mentioned international law?
There's 3 briefs that mention international issues.
Is that all of them?
That's all of them that mention it. But I mean, the most significant of which is the one from the UN mandate holders.
Who are the other 2 by? Do you know offhand?
Law professors and international organizations. So they're not as significant. The one from the mandate holders, from the UN mandate holders, is very significant. It's the first intervention of this kind in US.
I know that we reported that, and I take your word for it, but that seems astounding that UN actors have never filed a brief in a Supreme Court case.
Yes.
But you're standing by that.
It would be considered completely foul play. I mean, one of the principles of for the United Nations, on which the United Nations was founded, was non-interference in the internal affairs of states. So, of
course, they gave that up long ago, but yeah.
Well, they gave it up, but there's always been a semblance of it. I mean, when UN agencies or UN mandate holders go into a country, they have to be invited to do so.
Yeah.
Right. This is unprecedented that UN mandate holders unilaterally decide we're going to make an intervention in the US legal system.
Right.
That is very, I mean, if we had a State Department worth the money we spend on it, they would have lambasted the experts for even trying to do that. Yep. This is interference in the US judicial process by international mandate holders that have no business interfering.
We have a question coming from one of our listeners. I don't really understand. Is abortion moving into a court and UN topic rather than legislative? I'm not entirely sure.
It's moving in every level. Abortion is moving all over the place. Judicial, domestic, international, legislative, General Assembly. The abortion groups have so much money. They're so well resourced. They're able to push their issue everywhere. And that's why it's so important, I think, for the Supreme Court to actually say something on this issue, because here we have dozens, hundreds of recommendations from UN treaty bodies, from UN mandate holders, saying that abortion is an international right. They are increasingly interfering in our domestic policy debates at all levels, at the state, in the Congress. There's this effort of the Democrats in Congress to have abortion declared an international right. The Biden administration has seemingly suggested that abortion is an international right by welcoming recommendations to that effect in the Human Rights Council. And so here we have the executive branch, we have the legislative branch. They're all talking about what human rights are, what our human rights obligations are under international law based on what UN experts say they are. But the Supreme Court has never said anything about this.
Now, in our brief, we do not make the case. Now, this has been a debate in the international pro-life movement. It's kind of died down, but it used to be fairly intense. And that is, some people make the argument that the unborn child is absolutely protected in international law because of a couple of things that human rights documents protect every human being. And some other things with regard to the death penalty for women in prison who may be pregnant. The case that we have made is that governments are absolutely free to cite their own interpretation of international law to protect the unborn child, but that international law does not require them to. And we make that case in our brief, correct?
Correct. So basically, because of the way UN treaties were negotiated, involving both, on the one side, laws that had countries that had laws protecting the unborn, as well as communist countries that permitted abortion. And we're talking about the 1940s and 50s, when the majority of civilized nations outlawed abortion, and only the Soviet aligned countries permitted abortion. And so because of the United Nations was an attempt to bring everyone together, including communist countries, the way these obligations were crafted were vague enough that they can be interpreted as both allowing broad protections for the unborn from abortion, as well as allowing countries to legalize abortion. Now, you can debate further about whether allowing abortion is consistent. But the question here is not about consistency, but what are the positive obligations of countries under these treaties? And there is no positive obligation to outlaw abortion under these treaties. There is, however, a positive obligation to protect life. It doesn't say, and in the Convention on the Rights of the Child, it even says expressly before birth. So, we know that international law should be used to protect life in the prenatal phase, but we also cannot say that international law bans abortion.
Yeah,
but
I also want to emphasize for the people watching, one of the great successes of the UN pro-life movement over the years is to ensure that abortion has not become an international human right in UN documents, either binding or non-binding. I mean, this is one of the great victories of our movement. Our job from day one was to ensure that abortion did not become an internationally recognized human right in UN documents, and we have won that. I mean, we fight it constantly, but we have basically won that. We got a couple of questions here. Somebody wants to know, do amicus briefs make a difference? I would say some do, some don't.
Yeah, no, absolutely. Some amicus briefs may be read. I mean, I think if you have a UN mandate holders doing this unprecedented thing of submitting an amicus court brief, I think that'll get the attention of some of the Supreme Court justices. I have no doubt that it'll come up in oral arguments, and as Austin said, that the issue will be debated in the final resolution of the Dobbs case, however it is resolved. So the purpose for us is submitting an amicus brief is to give the clerks and all those working on the Supreme Court some further documentation and argumentation on an issue which they probably haven't thought about very much at all, whereas we've been thinking about it for over 20 years.
I am proud to point out that our amicus brief answering all these questions was submitted before the amicus brief of the UN mandate holders making the argument. So we answered all these questions prior to their amicus brief arising. Someone else wants to know, is there somebody then who should oppose the UN getting into this Dobbs v. Jackson case should the Supreme Court not reject it? I'm not sure what that means, to reject, that the Supreme Court should reject Dobbs v. Jackson. I think the
I
answer.
think they're getting into the UN intervention, the UN mandate holders.
Oh, and whether the Supreme Court should reject the intervention?
Yeah,
Maybe
and yeah, definitely the Supreme Court should reject the intervention, and the right, but the Supreme Court should definitely opine on what the UN mandate holders say, because to ignore it would open up the United States to accusations of ignoring human rights, and that's how they will be used by activists all around the world. So the Supreme Court should definitely rebut the claims that abortion is an international right. But I think the State Department is the right organ to also reject the intervention from UN mandate holders and simply say that this is unlawful interference in the internal affairs of the United States. It contravenes the UN Charter, and
and we can talk about this offline. Maybe it's something that CFAM ought to do with our friends on the Hill, is generate some sort of statement of members of Congress rejecting this kind of intervention, because they have a say too. They have a say too. Now, the person who is asking about amicus briefs and their effectiveness is saying that he has a ringside seat to an amicus brief on a related issue, which is obscenity law. Bravo. Most pornography today is prosecutable, actionable, based on existing laws on obscenity in the United States. So he wants to know, do justices read these briefs? Do they influence their decision making? They do. Like I said, some do, some don't. It depends on where they come from. But I say absolutely, people who have something to say with regard to the constitutionality of these things ought to say them in these types of briefs that can be submitted. So we're at 11:57. We're basically in an hour into this, and I don't want to go beyond an hour. Stefano, the next thing that's going to happen is oral arguments for December 1st. Are you going to come down and get in the lawyer's line?
I certainly will. I'm not sure about what the COVID restrictions are yet. We're looking into the possibility of, but I will certainly follow closely the oral arguments. And I'm looking forward to hearing the Supreme Court say something about international human rights law and abortion, because if the Supreme Court doesn't say something about it, UN experts certainly will, and the Democrats certainly will. And so if the Supreme Court doesn't speak, others will speak for it.
I would just say hats off to you, Stefano, for this magnificent brief. It is something that we need to get out to our friends and foes. I don't know what's going to happen. It seems to me, and Robbie George made this case recently in an article in First Things, if the Supreme Court doesn't take this opportunity to overturn Roe v. Wade, it will, I don't know the exact phrase that he uses, but essentially permanently harm the conservative legal movement in the United States. And I think that it will do deep harm to the pro-life movement. My fear is that hopes are so high that if this court does not overturn Roe through the Dobbs case, it will do a lot of harm to the pro-life movement. I think the pro-life movement is remarkably resilient and will not give up. And this is one of the things I say to people who criticize the political pro-life movement or the legal pro-life movement. It's not the end of the pro-life movement. That's not the sum and substance of the pro-life movement. The pro-life movement is broad and deep and vast, and there's something for everybody to do. You can stand outside of an abortion clinic and pray. You can talk to women heading into abortion clinics. You can come to the United Nations and lobby with us. Heck, you can lobby the State House. I mean, it is one of the most successful political movements in the history of the United States, right alongside the civil rights movement. Just come to the March for Life and see 500,000 people coming there every year in and year out on the most bitterly cold days. So I hold out hope that something magnificent is going to happen, and it's not going to happen until June. Is that right, Stefano? They hear arguments December 1st, and they will hand down their ruling sometime in June of next year.
Yes, June, decision week, they call it, when all the decisions of the Supreme Court are released at the beginning of the summer.
I would urge everybody listening to watch closely and pray, especially for divine intervention with Kavanaugh, Barrett, Gorsuch. You know, I don't think that Thomas needs our prayers to do the right thing, but he needs our prayers anyway. Pray especially for Roberts, who's become kind of squishy in some ways and a huge disappointment. But as the president of CFAM, I want to say hats off to Stefano, Lisa, Alexis, Rebecca, for all the hard work that you guys have done to bring us to this point in the debate over abortion and international law. So with that, I think that we will sign off. Stefano, any final words?
Yes, let's also pray for Sotomayor, Kagan, and Breyer for conversion and for mercy. Yeah,
amen. Thanks, everybody. We'll be back next month with another discussion of CFAM work. And God bless. See you then.
Thank you.